Can you imagine getting a bill for thousands of dollars just for the privilege, I guess, of selling your own home? Well, that is exactly what happened in a legal battle that really puts the power of homeowners associations on trial. This is a fascinating story about what happens when those community rules clash with your individual rights.
At the very heart of our story today is this number, $5,000. Yep, that's the amount of money a homeowner was told he had to cough up just to sell his property.
So, this brings up a huge question, one that affects millions of homeowners, right? When your HOA hands you a massive bill, is that just it? Or can you actually stand up and challenge their authority? We're about to break down exactly how one homeowner tried to do just that.
All right, so let's get right into the conflict. It all kicked off with this single $5,000 fee. Okay, so the charge we're talking about is called an HOA transfer fee. In theory, it's a one-time payment that an HOA collects whenever a house changes hands, to help fund community projects and upkeep. But here's the real legal question. What can that money actually be used for? That's the whole issue here.
So, let's meet the two main players in this fight. On one side, we have the petitioner, the homeowner, A.R.S. And on the other side, we have the respondent, the Montelena Master Community Association, aka his HOA.
And things got official on October 27, 2020. That's the day Mr. Ricks filed an actual legal petition. He wasn't just complaining anymore, he was formally accusing the HOA of charging him an illegal fee just to sell his house.
So, how in the world did he plan to prove that this fee was illegal? Well, this is where his legal challenge gets really, really specific.
This right here, this was the entire foundation of the homeowner's case. He didn't just argue that the fee felt unfair. No, he pointed to a specific state law, Arizona Revised Statute Section 33-442. And get this, the title of that law is literally Prohibition on Transfer Fees. I mean, that seems like a slam dunk, right?
His argument was actually pretty clever. He said, look, I know the state law bans these fees, but I also know there's an exception. But, and this is the key, he argued that the exception is super narrow. The fee has to be for a very specific purpose. He claimed that just saying it's for general operating expenses was way too vague. In his mind, the law required that money to be for something concrete, like building a brand new community pool or funding a specific landscaping project.
But you knew there was a but coming, right? The HOA had a powerful defense, and they argued they were perfectly within their rights to charge him.
And this really boils the whole case down to a classic showdown. State law versus the HOA's own rulebook. The homeowner is banking on the state law, but the HOA? They're pointing to their covenants, conditions, and restrictions, the CC&Rs. You got to think of these as the private constitution for the neighborhood, something every single homeowner agrees to when they buy their house.
So the HOA's case was built on a few really key points. First, they said, hey, our CC&Rs clearly state we can charge a transfer fee. Second, they pulled out a board resolution from way back in 2010 that specified the fee was to fund operating expenses and/or reserves. They argued this was a specific purpose and it totally met the legal standard. And then to top it all off, their lawyer pointed out that about 85% of the associations he represents have similar fees, basically suggesting this is just standard practice.
So we have two very different interpretations of the law. You've got the homeowner's argument on one side and the HOA's rulebook on the other. So how did the judge see it? Let's get to that final ruling.
But first, to really understand the verdict, you have to get this one crucial legal concept, the burden of proof. It basically means it's not the HOA's job to prove they're innocent, it's the homeowner's job to prove they're guilty of breaking the law. Just making an accusation isn't enough. You gotta have the receipts to back it up.
And in this case, the judge made it crystal clear. The burden of proof was entirely on the petitioner, Mr. Ricks. It was up to him to provide enough evidence to show that the HOA had actually violated the law.
So the judge first looked directly at the HOA's own rulebook. And bam, right there in section 7.15 of the CC&Rs, it says as clear as day that every new buyer shall pay a transfer fee.
And the second big piece of evidence was that 2010 board resolution. It directly laid out the purpose of the fee, to fund operating expenses and reserves. This pretty much blew up the homeowner's main claim that the purpose was too general or wasn't specified at all.
So here's the bottom line. The homeowner offered his interpretation of the law, but he didn't really provide any legal authority to back it up. The HOA, on the other hand, had their own governing documents, all laid out. The judge found that Mr. Ricks had failed to meet his burden of proof. So the verdict? Petition dismissed. The HOA won.
Now, that legal battle is over for Mr. Ricks, but the lessons from his case are incredibly valuable for any of us who are current or future homeowners. So let's talk about what this whole thing means for you.
So how do you protect yourself from something like this? Well, first, and this is the big one, read your CC&Rs before you buy. Seriously, this isn't just boring paperwork. It's a legal contract you are signing. Look specifically for any language about transfer fees. Second, understand all the potential fees. Ask for a history of special assessments. Those are the surprise, one-time charges that can really sting. And third, know your state's HOA laws. As this case proves, an HOA's rules are powerful, but they can't just ignore the law of the land. Knowing your rights under state law is your best and most important shield.
And that really leaves us with one final big question. If you live in an HOA, you're basically living under a private little government that has the power to tax and fine you. The biggest lesson from this case is that those rules have real teeth. So the question for you is, do you actually know the laws you're living by every day?